pour les spectateurs qui veulent regarder en français, appuyez sur le monde et choisir français. My name is David Fuhr, and I'll be your moderator for this afternoon. I serve on the Multi-Stakeholder Steering Committee that guides and organizes the Canadian IGF. And I'm General Counsel at SIPC, the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic. We're a public interest technology law outfit based at the Faculty of Law at the University of Ottawa. Our mandate is to intervene on behalf of the public interest in issues arising at the intersection of law and technology. So today's topic of our IGF session is near and dear to our hearts. 2021 marks the third year of operation for the Canadian IGF. Our events convene groups from across the Canadian internet landscape to address a breadth of critical issues related to internet governance, cybersecurity, and the roles of government, industry, and citizens in safeguarding this invaluable economic and social regime. The event is driven by a multi-stakeholder steering committee, and it's recognized as a national IGF event, a national IGF initiative by the Global Internet Governance Forum, which was established in 2006 by endorsement of the UN as an outcome of the World Summit on the Information Society. Normally, if we were not in a pandemic environment, the Canadian IGF would meet in person, and we would all have the opportunity to chat in the hallway over coffee. We hope to return to that state of affairs as soon as possible, but given the virtual nature of the world right now, the Canadian IGF Steering Committee has chosen to proceed with a virtual speaker series. The first one occurred in July and addressed a rapidly developing legislative agenda with respect to internet regulation, including the controversial Bill C-10. Today, we join you with a similar type event. We have an expert panel here to discuss a consultation that the Liberal government opened over the summer just before calling the election. The consultation proposed a regulatory framework for addressing harmful content that is distributed through online services. Then, during the election period, the Liberals committed to introducing legislation based on this proposal in their first 100 days of governing. The proposal is quite ambitious in scope. It addresses harmful material ranging from terrorist content to the non-consensual distribution of intimate images. It's also robust in its application, envisioning an entirely new regulatory body. Today, our panelists will share perspectives on the online harms proposal, identify potential problems with the proposed framework, and make recommendations for the course Canada should follow in addressing online harms. But first, a couple of housekeeping items. Most of you are joining us today via Zoom. We are also streaming the CIGF via YouTube. Second, the chat window is open for comments. Please remain respectful in your interactions. Also, ensure that you have everyone selected and not just panelists before sending a message. We also encourage you to take this discussion outside the event to social media. Use the hashtag for the event, #CIGF2021. And third, please submit any questions that you have for the panelists in the Q&A tab, also located at the bottom of your Zoom window. There's also the opportunity to ask live questions at the end of the event by raising your hand. Ensure that your mic is working correctly in order to ask a live question. With that covered, I'd like to pass it over to the panelists themselves to make their introductions. Please give us your name, your affiliation, and a high-level overview of your perspective on the online harms proposal. And we'd ask you to take no more than 5 minutes for this. We'll start with Jeanette and then move to Diana, Tara, and Ron. Jeanette.
Thanks very much. I'm Jeanette Patel. I lead government affairs and public policy for YouTube in Canada, and it's a pleasure to be here. I think, as many of you know, YouTube has been in Canada almost since its inception about 16 years ago. And in that time, we've seen how a platform like ours can be a force for good. It can connect people, build communities and small businesses, educate and entertain. It's a powerful creative ecosystem where Canadian creators are punching above their weight. And we saw that last year, YouTube's creative ecosystem contributed almost $1 billion to Canada's GDP and created over 34,000 jobs. So it brings a lot of value to our lives. But we've also seen, unfortunately, how the challenges that come along with an open platform, as societal ills play out on that platform in, quite honestly, are completely unacceptable ways. So keeping our users and creators safe is our #1 priority at YouTube, and we recognize that dealing with these issues is a critical part of the role that we play. That's why we've been investing in building out our systems, teams to enforce our community guidelines. And it's a dynamic and ongoing process of continuous improvement, and that we've been investing in over a number of years. So as Canada worked to establish a regime to govern user content online, we wanted to share the learnings that we've taken away from our experience. So as you may know, we made our official comments into this process public earlier this month, and I would encourage you all to take a look and go through that. But if you haven't had an opportunity to read our 25-page submission, I'll give you a quick overview. So I'm going to focus on 4 elements of the proposal. The first is the scope, then the trigger, the timelines, and the potential for proactive monitoring. First, when you look at the scope, as David mentioned, it is an ambitious proposal. And really this comes down to how wide does the government cast the net? The proposal specifies tackling 5 categories of harmful content that are already illegal in criminal code as defined in the criminal code. But it then went further and suggested that those definitions would be adjusted for a regulatory environment. And that raised questions and concerns for us about the expansion or the potential expansion of those concepts, and the possibility that we would arrive at a point where the Canadian government could have different and inconsistent standards for what Canadians can say offline versus what they can share online. And that poses a challenge in our minds. And so we would recommend that the government avoid that risk by relying on the definitions already available. The second is really when it comes to the trigger. And that the proposal contemplates simple user flags, starting the clock for platforms to remove content. And when you consider that we operate at a scale where we receive at YouTube alone over 190,000 user flags daily, we consider them to be important signals in our system, but they are not foolproof and should not trigger legal obligations to remove content in a 24-hour time period, because flags can be misused. They can be applied to legitimate content that a user may simply disagree with, or in fact, they can also be abused and used to target and silence opponents. So we're concerned that as currently contemplated, this system could be vulnerable to abuse, and we feel that the government should add guardrails like formal legal notice, as is done in Germany, to reduce that risk. Thirdly is the turnaround time. Imposing a 24-hour turnaround time to address user flags at the scale in which we operate simply does not account for user error or the contextual analysis and legal tests that are required for many of these issues. Some cases require a nuanced consideration of context, intent, and impact in order to determine if they meet the definitions that we're talking about. And platforms simply require the flexibility to perform that nuanced analysis. Finally, I'll note that the proposal speaks to a potential requirement to use automated systems to detect and block potentially violative content. And this would require platforms to scan all uploaded content and use machines to make decisions about blocking content that they're simply not equipped to make. Understanding context and nuance are important factors in assessing content, and that's not a strength of machine learning models. Automatically removing content is not always the right decision in every circumstance. And that's why at YouTube, we have a partnership between machine systems and human reviewers. When you look at it in total, taken together, our concern is that the regime would, as proposed, would lead to the removal of over-removal of legitimate content, and it is subject or vulnerable to abuse. We feel like service providers would inevitably be incentivized to remove any content that's remotely questionable. And, I think that this is a really challenging space to navigate, but I actually also think it is possible. We do see a roadmap to landing in the right place. I think that are some course corrections that need to be made, but fundamentally, we think that this is something that we can work with the government to accomplish together. And I'll close there and turn to my fellow panelists. Thank you.
Thank you very much, Jeanette. We'll turn now to Diana.
Thank you very much. Hello, everyone. My name is Diana Giorgio. I'm a legal and policy officer at the Child Rights International Network, or CRIN for short. CRIN is a think tank based in London, and our legal and policy work covers the full range of rights of children and young people. So my aim today is to bring an international children's rights perspective. So I will start with a statement of principle and then make 4 points about the substance. So, statement of principle, all children's rights from protection from violence to freedom of expression and privacy apply in the digital environment. Therefore, any proposal for online harms legislation should aim to achieve a balance between the various rights engaged and not prioritize one set of concerns, like, for example, the protection from harm at the expense of other freedoms. So before going into the substance of the proposal, we understand that concerns have been raised by civil society about the timing of the consultation process and Canadians' ability to meaningfully engage with it. Under international law, all children have the right to have their views heard and taken seriously in all matters that affect them. This is one of the fundamental principles of the Convention on the Rights of the Child. Children's views should be considered in decision-making, in policy-making, and in the preparation of any relevant laws and measures, as well as in their evaluation. Now, online harms legislation regulates behavior that involves and affects children, and it impacts them disproportionately. The consultation process, therefore, must be robust, and it must include the views of children. Now, looking at the substance of the proposal, to us, it is not clear what its scope is. And as Jeanette was mentioning, the proposal refers to 5 types of harmful content. The definitions are said to borrow from the criminal code, but will be adapted to the regulatory context. And we understand that in practice, this means a broadening of these definitions to capture conduct that is essentially legal under Canadian law. So looking at the concept of child sexual exploitation content, it should capture beyond criminal law offenses material that may not constitute a criminal offense, but when posted on an online communication service is still harmful to children. So why does this matter? Canada is not proposing sweeping legislation that would deal comprehensively with harms online, like the UK is doing, for example. But even with a more contained, a smaller scale proposal, it still faces some of the same definitional problems. Expanding the scope of the proposal from content that is illegal to content that is legal but harmful is very concerning. Under international human rights law, restrictions on freedom of expression are permissible only if they have a legal basis, pursue a legitimate aim, and are necessary and proportionate. To comply with these requirements, the forms of harm and the concept of harm must be defined very clearly and precisely. Otherwise, there is bound to be uncertainty and confusion, and that will result in impermissible censorship and the infringement of users' rights. So this leads us to the next point about how feasible or not it is to comply with the obligations set out in the proposal as an online communication service provider. So they must take all reasonable measures that can include, as Jeanette said, the use of automated systems to identify and remove harmful content. And again, looking at the requirements of lawfulness, necessity, and proportionality for restrictions of certain human rights, we see that in some cases, it will be straightforward to determine whether the restriction can apply. So for example, the identification of child sexual abuse material through hashes. In other cases, like terrorism and hate speech, the proportionality part of the human rights analysis requires looking at the context. And of course, this is something that automated systems are not well equipped to do, and that human reviewers without the proper training might find it difficult. So the stringent obligations placed on service providers need, in our view, to be reconsidered. And my final point relates to education and digital literacy, in a way as a response to the idea that legislation and or technology are the silver bullet that can prevent harms online. There is little mention of education and digital literacy in the proposal. The Digital Safety Commissioner is said to have the function, among others, to engage in partnerships, education outreach activities, and research to help fulfill the policy objectives of the law. We believe that media and digital literacy should be given more attention and that there should be a particular focus on the needs of children, especially those from disadvantaged communities. So these are just some of our initial thoughts, but thank you very much.
Thank you, Diana. Kara?
Thanks. Hi, my name is Kara Zwiebel. I'm a lawyer and a director of the Fundamental Freedoms Program at an organization called the Canadian Civil Liberties Association, or CCLA. The CCLA is a national nonprofit organization that does work across Canada to protect and promote the rights and freedoms of people across the country. Some of the issues that are front and center for the CCLA in this proposal, I guess there are both sort of procedural side issues and substantive issues. So on the procedure side, I guess I'd start by saying that the way in which the government has introduced this this consultation, and I would use air quotes probably around that term, is by putting forward what is essentially a draft piece of legislation, kind of reworked into a briefing document. And it appears that the consultation is more about sort of providing notice to people and checking in. And a lot of decisions appear to have been made. So that's a problem, as a civil society organization that is interested in participating in policy dialogues about these issues. And certainly the submissions that have been made public from organizations that have contributed to this consultation are fairly critical. And many, suggest that there's a need to start again in terms of a consultation, that we shouldn't be rushing to put forward, a piece of legislation. We should do a broader consultation and a more meaningful one. And I would agree with those criticisms. Substantively, I think that I agree with, a lot of what Jeanette and Diana have already mentioned. I think that the proposal creates a system that is likely to lead to the over removal of content. It creates a lot of procedure and a lot of sort of bureaucracy around dealing with these issues, and it's not clear that approach is really well tailored to the scope and scale of our online communications. I mean, we are talking about this proposal regulates not just what Canadians do online, but basically anything that Canadians have access to online. And so it's a huge amount of content that we're talking about, and a huge amount of potential, flagging and decision-making that needs to be made around whether content falls into the prohibited categories. In terms of the prohibited categories, there are 5 things that are referenced in this proposal: terrorism content, hate speech, child sexual exploitation, incitement to violence, and non-consensual intimate images. And I would say that those things are not, I think sometimes I don't know if anyone remembers on Sesame Street, there used to be that, one of these things is not like the other. I think that that's the issue with this proposal. Some of these things are really not like the others. As you've heard from some of the other panelists, when it comes to something like child sexual exploitation, machines might be very good at picking up content and blocking it, and much less good at the kind of contextual analysis that's required in assessing whether something falls into the category of terrorism content or hate speech. The other significant thing and very concerning thing from a civil liberties perspective that the proposal does is talk about mandatory reporting by social media platforms to law enforcement. And not just law enforcement, but actually national security bodies like CSIS, the Canadian Spy Agency. So this is a piece of the proposal that I think caught many people a bit off guard, and something that really does sort of deputize corporations to act as law enforcement, and not only requires them to report, but also requires them not to let their users know that they've reported. So those are concerning things from a privacy perspective, from a due process perspective. there's certainly more that could be said about, some of the issues here, and I'm sure we'll talk about that, but I think I'm around at 5 minutes, so I'll stop now and defer to the rest of the panel.
Thanks, Kara. Ron, over to you.
All right, thank you. Well, definitely great to be here and pleased to have a chance to speak about this important topic. My role, I'm the VP of AI engineering and CIO at the Vector Institute and engineering lead at the Schwartz-Reisman Institute for Technology and Society at the University of Toronto. So Vector is one of the Pan-Canadian AI institutes sponsored by both the federal government and the government of Ontario, as well as industry sponsors. It's a community of about 600 researchers in leading edge artificial intelligence and professionals supporting the mission of research to benefit the public in Canada, using artificial intelligence. And at Schwartz-Reisman, the focus is really on an interdisciplinary institute to look at how we make sure technology improves the world, with a real emphasis on the governance of AI. And so I think that the intention of this consultation is a good one, right? To say, how do you mitigate online harms? But I'll suggest a number of areas where I think really recalibration is important. One is definitely agree that the capabilities of today's artificial intelligence systems, while rapidly improving, are not there yet to be able to expect extremely high precision and accuracy in determining whether a given piece of content violates the law, right? So rather than given the scale of these digital platforms, it's incredibly important to have a thoughtful approach for how do you govern impact, right? So I think there's, on the one side, if you think about a goal of reducing harm from online content that's illegal, you can't go from a situation where there's no regulation to expecting to suddenly eliminate a problem like this, right? So just like we didn't get to improved fuel economy and perhaps eventually all electric vehicles by overnight mandating no gas cars, all electric, right? Instead, there was a process, right? And so in the same way, it's a valuable, important idea to say, can we start to have metrics, right? In fact, many of the platforms involved are tracking violative view rates, right? To say how much content is violating terms, right? And there's room to do things like have standards around those metrics and to track progress and to say, like, is a given provider failing because they're below the standard that's being achieved in the industry, and it's a problem, right? So you can measure that in a more aggregate way rather than looking at it on a zero tolerance, each instance is potentially multiple % of annual revenue fine for not taking down content, right? So I think there's a better way to get the goal by tracking metrics in aggregate and having standards. I think it's also important, and I didn't see anything in the regulation to deal with this concept that Jeanette talked about of nuisance complaints and people, or worse, right, deliberately silencing or targeting people, right? That measuring, likewise, you not only want to have metrics around is bad content being taken down, but what's the collateral damage? How much content is being taken down that subsequently turns out to be legal or not violate terms of service? That's the other side that needs to be tracked, right? You have to think about the balance, and I know that Deanna was talking about that earlier as well, about balancing the harms. I'd say that it's also incredibly important, though, that as part of this, I just came back from Paris, where the Global Partnership on AI held its annual summit. For those not familiar with GPI, it is an international organization co-founded by Canada. Canada just had the presidency of the organization this year. And one of the working groups that I've gotten involved in is around social media governance and saying, like, how do we have better visibility in the legitimate public interest around where there may be harms being caused by social media platforms? And I think the report of that working group from this year and projects envisioned around how do you allow visibility into what's going on so you can have external audit and understanding of harms is a really useful direction, right? So I think having ways to allow for external researcher access and visibility is an important direction. I'd also say that I think that in a sense that this definition of online harms is too narrow in the sense that there are externalities that can happen for legal content that, for example, if something creates addiction or depression, that may not be from illegal content, but it could still be a harm, right? Just like pollution is an externality, even if it's not illegal to pollute, right? So I think there's room to think about more nuanced ideas than banning or blocking, right? That there are other ways that technology can play roles to mitigate harms that don't necessarily involve blocking content. So those are some thoughts, and I look forward to the discussion today.
Thanks, Ron. Now we'll move on to the questions component of our session today. We've got a few kind of prepared questions that we'll start with. And the first is, having given your critiques of the legislation, we're about to see, according to this government, a bill dropping in the not too near future. What would you like to see in that bill that would address at least some of the critiques that you've offered? Why don't we start? We'll just go through the same group. So we'll start with Jeanette, same order.
Okay, thanks. So the four things, right? So in terms of, I think, now I'll just kind of go back to, I do think there is a path here, right? This is achievable with some course corrections, focusing first on the definitions that are already available to us in terms of illegal content. So restricting scope to clearly defined illegal content and not expanding the definitions. The second is around safeguards around for what triggers the process for review. So in other jurisdictions, they use formal legal notice, and it's a kind of separate work stream for content that is being reviewed for its compliance with the regime. The third is around the timelines and building in flexibility for platforms to adequately assess the content that's been flagged. And then finally, avoiding any requirement for the use of automated systems to filter and block the upload of content that is potentially concerning.
Thank you, Jeanette. Diana, what are your thoughts? What would you like to see in the legislation that would address at least some of your critiques?
Thank you. So yes, just to take my points in turn. So regarding the right to be heard, guidance regarding the application of the Convention on the Rights of the Child states that governments must undertake a continuous process of child rights impact assessment to predict the impact of any proposed law on children and the enjoyment of their rights. So any evidence on which the government bases its approach must include evidence from children and young people. Regarding the scope of the proposal should be clarified with regard to the legal but harmful aspect. The narrower and more precise the restrictions on fundamental rights, the better. And in particular, there should be democratic oversight over the type of content that is covered, and executive interference should be kept at a minimum. And this might require, for example, debates about the extent to which it is appropriate to criminalize content that is not currently illegal, but which is harmful. But in any case, we believe that these robust debates might be preferable to just vague definitions of harmfulness and resorting to regulation. On technical feasibility, the obligations placed on online communication service providers should be reconsidered, and the 24-hour takedown time limit, which, as we understand, might even be shortened in some cases, should be scrapped in favor of an obligation to deal expeditiously with the flagged content. And it should also be made clear that there is no general obligation on the part of service providers to proactively monitor all communications for harmful content. And in terms of digital literacy, again, the United Nations Committee on the Rights of the Child provides in its general comment on children's rights in relation to the digital environment that digital literacy must be taught in schools from preschool level throughout the school years. And in our view, there should be an emphasis on critical thinking and on evaluation, and even include things like content creation, because the responsibility to protect children from unlawful or harmful content online is really a shared responsibility. So companies, governments, civil society need to collaborate to inform and engage the public. That may be children, parents, teachers, adults, other responsible adults, to engage them as citizens, as digital citizens. And again, special attention should be given to the needs of children from disadvantaged communities. So we would like to see that featured more prominently. Thank you.
Thanks. Kara.
Yeah, so I mean, I agree with a lot of what's been said in terms of changing or lengthening the timeline, or being more permissive in terms of the timeline if we're going to talk about requirements to remove content. I certainly am not in favor of the proactive monitoring approach that is really a prior restraint on on freedom of expression. I think also we'd need to look really carefully at the mandatory reporting provisions and either remove or narrow them. The mandatory reporting is something where there was actually a little bit of a question in the consultation document about which approach to use. So, but I think those mandatory reports need to be quite narrow. And I would also, we're talking about, I guess, different things we'd like to see in this bill, assuming this bill gets introduced. But I think there's also it's worth talking about other approaches to regulating the online environment that doesn't start at the level of content. So that is focused maybe on issues around competition law, maybe on issues around monetization and advertising. But I think that to start at this level might be a problem. And I would also say that it might be a good idea to separate out some of the different harms and treat them under different regimes. I think that child sexual exploitation in particular. I've listened to these policy debates and still don't fully understand why this is such a challenge for law enforcement to deal with this, with the content online. So I'd like a better understanding of that, and I'd like to understand what tools they really need. But it seems like that particular harm area is quite distinct and different from the other categories of content that are treated in the proposal.
Thanks, Kara. Your answers anticipated a few of the follow-up questions we're going to have. But before we do go there, let's go to Ron. Ron, I'm curious to see what kind of legislative solutions you'd like to see that can address some of the technological tool critiques you've offered.
Yeah, definitely. Well, I think one is, again, rather than moving to the kind of case by case, individual piece of content approach that's in the current consultation, I think instead coming up with standardized metrics that can be audited and measured with confidence externally around not only the extent to which illegal content is being viewed, but also to the extent to which legal content that is not violating terms of service is being taken down, and metrics on complaints is one important aspect. So I think rather than trying to set zero tolerance around any content that is illegal, instead it's about measuring how effectively in practice platforms are doing at preventing that content from getting out and limiting the damage from it. So that would be one thing I think could be a big improvement. Another thing I think is incredibly important is to allow for vetted researchers to have access to do research to understand the broader impact of online harms, not only from illegal content. This is aligned with some of the proposals in the European Union's Digital Services Act, right? And the notion of having researchers, and again, very much aligned with how the kind of studies that the Global Partnership in AI is conducting to allow external researchers to be able to really have good evidence about the impact of harms in online systems. So I think that's another positive direction that could really allow the public to have more confidence and insight into the extent of harm or lack thereof through effective research. I think another direction that could be really powerful would be, ultimately allowing for more algorithmic choice, right? So I think a key thing that, for example, many parents would like is to have more ability to control the experience of their children, what's prioritized for them in their social media feed, and what, are things, interfaces being placed in a way that are creating harms, right? And I think that is less about illegal content and more about things like increasing depression or eating disorders or other harms, right? Where again, I think the ability to allow some market choice around the way that consumers experience these platforms could be incredibly powerful. Now, there's meaningful technical work that would need to be done to deal with the obvious challenges around privacy and adversarial action. So I'm not saying that's a trivial thing, and I don't think it can be quickly written into law, but I think a process could be started to allow for that kind of algorithmic choice that could really give agency to individuals in this space.
Thanks, Ron. Our second question for the panel tackles the problem of these 5 different kinds of online harms all being dealt with in the same regulatory regime. So the question that I have is, do the 5 categories merit the same regulatory regime, or should the different categories of harms be approached differently? And just a refresher for everybody, the 5 categories outlined in the Council documents are terrorist content, content that incites violence, hate speech, non-consensual sharing of intimate images, and child exploitation content. We'll start we'll start in the same order. Why don't we go with Jeanette first?
Okay. So I think, whether you split up the bill or what the actual technical approach is, I would say the principle here is that it's reasonable to have different obligations or different parameters applied to different types of content. And Kara and Diana are correct. And when you have something like child sexual exploitation material, there is a system in place to ensure that is our number one priority. There is nothing that we act faster on. That is always going to be at the top of our list. And we have a system to refer that to it's called NCMEC, the National Center for Missing and Endangered Children, so that they can get that to the right legal authorities. And I think that, you look at what I want to avoid is a scenario where when you treat all content at the same level of, with the same priority level, and you're not able to triage, you can bury some of the problematic content, right? And so we need to have a system that addresses the fact that that you do need to triage some of these categories of harm, and that some of them, to the earlier points, require a more thorough assessment, right? Canadian law, when it comes to, and I am not the lawyer, Kara can speak more to this, but Canadian law requires an assessment of context, it requires an assessment of intent, and it requires an assessment of likely impact. That is something that, when you're dealing with individual pieces of content, that requires human analysis and legal analysis that I think that you want to be able to build a system for. So, that's a long answer to your question, but I think that basically we need to have something that that addresses the fact that these are different categories of harm, and perhaps whether it's dealt with in one law and applies obligations in a differential manner, or if it's dealt with separately, I think that we do need to accommodate for those differences.
Diana, your thoughts? Do the 5 categories merit the same regulatory regime, or should we be attacking these problems differently?
Thank you. Yes, I think there is some agreement that the 5 categories are quite different in nature, and that some of them, and in particular child sexual exploitation content, have much clearer legal boundaries than the others, and require less of a nuanced assessment of context. The advantage of a tailored approach, as we see it, is that a tailored approach limits the interferences with fundamental rights. It's not legislate first and wait for the tech to come later approach, which is something that we see in other countries dealing with legislation on online harms. A consequence, of course, if these categories are dealt with in the same legislation, will be that the level of complexity of the legislation will increase, with different duties corresponding to different types of harm.
Thank you. Kara, you've given us a hint of your answer here. You want to elaborate?
Sure. Yeah. I do. I mean, I think that, again, whether it's all in one bill, but there are different sort of obligations or different treatment for these different types of content, I do think that it's worth looking at the specifics of the type of content we're talking about and what we're trying to achieve with it, and recognizing that some may be more amenable to review by machines, and others may not. The piece that Jeanette mentioned in terms of context, I mean, if you look at the category of hate speech, our courts that have adjudicated cases dealing with hate speech, their definition of hate speech is a fairly narrow one. What a lot of people might consider to be hate speech is not actually legal hate speech under the definition that our courts have laid out. And even that definition, which has remained relatively stable for about 30 plus years, there is not necessarily agreement among judges that look at a particular piece of content as to whether it falls on the right or wrong side of the line. So those are difficult calls to make. It will require context and nuance and training, and I think it's worth treating those things in a different way than something like child sexual exploitation. In Canada, our child pornography laws don't just make it illegal to create child pornography. It's illegal to do almost anything with child pornography, to view, to access it, to distribute it, to manufacture it. So that is a bit of an easier call to make legally, and I think that it is worth treating those things differently. And similarly, when it comes to potentially imposing, reporting obligations on platforms to report to law enforcement, we need to take seriously the potential for some of our unconscious biases to work themselves into reports related to hate speech and terrorist propaganda, things that are probably a bit easier to avoid when we're talking about child sexual exploitation.
Thanks, Kara. Ron, your thoughts?
Yeah, well, I definitely concur with the other panelists that you have to have differences based on significant difference in legal status or complexity of assessing the different types of content. I mean, I do think that a regime that, especially one that might move towards more of a aggregate metrics approach, could have different metrics for different types of content, and you could certainly have different thresholds in terms of, it should be easier to quickly take down child exploitative content than perhaps more nuanced topics like, is this hate speech, right? So I think there's room to have different treatment of different types of content, but I actually do think having some something more systematic, rather like the risk of having a series of independent bills addressing this is that you would end up with incompatible and complex mechanisms. So I do think there's value in having some consistency in how it is being dealt with, even though it's important to respect the differences in the different types of content.
Thanks, Ron. So having had a quick discussion now about the 5 categories of speech that we're dealing with in this proposed legislation, we're going to turn to a question to the panel about mandatory reporting, but also a poll to the audience about mandatory reporting. So the question for the poll is, which of these 5 online harms is suitable for mandatory reporting, if any? I've pasted the 5 categories for you to ruminate on in the group chat, and our organizers will make the poll available to you. While you're participating in that, let's turn to our panel and get their views on mandatory reporting. So, but before we do that, let's take a look at what the technical paper had to say, the consultation paper. It said that the act should either require that a service provider notify the RCMP in circumstances where the service provider has reasonable grounds to suspect that content falling within the 5 categories of regulated harmful content reflects an imminent risk of serious harm to any person or property, and then provides for the potential for regulations. The other mechanism that the consultation paper discussed was simply that the cabinet could issue regulations that prescribed certain information to be reported with respect to the 5 categories of regulated harmful content. So there's a lot there. The question to each of the panelists is it appropriate for service providers to be obliged to report this kind of content and user data under these circumstances where there's a serious risk there is reasonable grounds to suspect that there's an imminent risk of serious harm? Why don't we start, why don't we go in the reverse order this time to give Jeanette a break? We'll start with Ron. What are your thoughts on mandatory reporting?
You know, I think it's important to understand, how accurate a given ability to assess a given type of illegal content is. That that it's an important topic to say, like, what's the right threshold for each of the different types of content. I believe that few of these types of content you can have the level of confidence to automate reporting in a way that would be high confidence. Although I understand that there's certainly of the types, child sexual exploitative content is probably one where the ability to have a high threshold of confidence, and of course the urgency of the matter, is the most persuasive. But it's also we're less experts in the topic around specifically the trade-offs of reporting. But I do think the quality of the ability to use AI to detect these things, the level of confidence is an important factor to consider.
Thanks, Ron. Kara?
Yeah, I think, I guess the way that the questions posed in the consultation really does presuppose this kind of proactive monitoring of content, because the requirement of imminence really only sort of makes sense in that context. And so, I think if we're going to reject that approach, and I think in general we should, then mandatory reporting is problematic in any of these areas. But we do already have some requirements for, and Jeanette mentioned, the way that child pornography or child sexual exploitation material is already reported. I think one of the things that this proposal tried to do was maybe redirect where that's reported. And I think there are, complicated questions about how that works when you have a global system, and you don't necessarily know where the content may be coming from. But certainly I think that the strongest case that can be made for mandatory reporting would be with respect to child sexual exploitation. And I agree with what Ron said. I mean, imagining a machine deciding what gets reported to law enforcement or to CSIS is a really frightening proposition, and not a road I think we should go down.
Thanks, Kara. Diana, your thoughts?
Thank you. Yes, I agree with a lot of what Ron and Kara were saying. And just from a children's rights perspective, mandatory reporting, and especially mandatory reporting of potentially illegal content posted by children, gives me a great deal of concern. And it's not just because of the worrying implication of data collection for children's right to privacy, but also because it is, in effect, one way to bring children closer to law enforcement and to intelligence agencies, and in a way to the criminal justice system, instead of focusing on diverting them as much as possible away from the criminal and juvenile justice system, as states must do in international law.
And over to you, Jeanette.
Yeah, I'll echo some of the concerns of my fellow panelists, and I'll just add, I think it's important to keep in mind that we have no objection and we support voluntary reporting, and we have a clear system and process in place. I think our concerns really center around privacy implications and fundamentally due process. Right, so just ensuring, right now, the Canadian courts have held that you have to have a production order to obtain user data from service providers, and so we just need to have a system that maintains due process and doesn't circumvent that. I think the other consideration here is that, when you think about something like child sexual abuse material, which is the most egregious kind of content, you absolutely need to get that into the hands of the right law enforcement quickly. This kind of material is often global in nature. It's not limited to one jurisdiction, unfortunately. And so, by working with an organization like NCMEC, they're able to have connections across the world and make sure that that law enforcement is able to treat that in an expeditious manner, as opposed to really kind of opening the floodgates for Canadian law enforcement and expecting them to navigate the international elements of this. So I think there's both, concerns around the principles at stake here, as well as the real practical implications that could have serious harmful impacts for the victims involved.
Thanks, Jeanette. Yeah, this question, it raises some of those kind of traditional constitutional law debates about what's the appropriate threshold. Here, the threshold is on a private services provider to have reasonable grounds to suspect. They haven't even gone so far as kind of the more traditional reasonable grounds to believe that there's a serious risk of harm. So I'm sure there's going to be debate, when the bill is finally introduced, and then once it's introduced and passed, I'm sure that the courts will be dealing with this, which raises our next question. Do you have any concerns about the interaction between this proposed framework and the Charter of Rights and Freedoms? We'll do the same reverse order. Ron, any thoughts on this?
Well, I'm not a legal scholar, so I think I'll pass rather than try to wade in on this one.
All right, we'll let you get away with it this time. We'll go to Kara, who I know has thoughts on the application.
Yes, certainly. I mean, I think, what we're talking about really is, it is regulating the way in which Canadians communicate. So there are freedom of expression concerns, there are privacy concerns when it comes not just to mandatory reporting, but also, there are some good things in the proposal in terms of requiring the platforms to be more transparent about the way certain things work. But I understand that some of those requirements might also require the platforms to actually collect more information about their users. So that seems counterproductive. And so I think there are certainly a lot of, the standard with the Charter of Rights is that, rights, the government can restrict and limit our rights, but they have to do so in a way that's reasonable and justified. And I think when it comes to looking at the breadth of some of these proposals, that just to take the last example, right? So it's a reasonable grounds to suspect, which is already a low standard, and it's to suspect that that a piece of content falls into one of these categories, and those categories themselves have a lot of blurry edges, right? It can be difficult to discern whether something is terrorist content or hate propaganda or hate speech. So, so there are very real concerns about whether this kind of approach is reasonable and demonstrably justified. And I think that one thing that the government hasn't done particularly well with this proposal is explain what evidence they're relying on to say that this is a regulatory approach that's actually going to be effective. I think if you look at some of the regulatory approaches that they're drawing on, some of the European approaches, some of those have been challenged and struck down as contrary to constitutional guarantees or rights guarantees. And some of them have definitely demonstrated the potential for removing more lawful content, because there's an incentive to remove content. So I think that there are very real constitutional concerns about this proposal, and I'm certain that will be the focus of a lot of discussion if and when the bill is introduced.
Diana, your thoughts?
Thank you. Well, I'm not a Canadian lawyer, so I will refrain from commenting on the Charter of Rights and Freedoms, but what I can say is that from an international human rights perspective, a number of features of the proposal very obviously raise concerns in terms of the lawfulness, necessity, and proportionality criteria that we mentioned.
Jeanette, any thoughts on this?
Well, I think what I'll say here is that it's clear that there's going to be a debate about the constitutionality or the compatibility with the Charter of Rights and Freedoms. And so I think the government has an opportunity here to make some adjustments, do a bit of a course correction, and reduce the risk of creating that, of feeding into that debate. So, I think that by being a little bit more contained in the approach that they take, and by removing some of the really challenging and problematic elements of the proposal, they have a clearer path to actually accomplishing the objectives here. Because I think it's important to remember that, from my perspective, doing nothing and kind of walking away from this initiative is not what good looks like. I think that there is, a very legitimate conversation to be had. There's, this is something that is important work. But the challenge I see is that by pursuing something overly ambitious that treads into these waters of charter questions, we risk really bogging this down and not actually accomplishing what the government set out to do. So that's why I think our advice is really to look carefully at the proposal, make some adjustments so that it doesn't run into that outcome.
Thank you, Jeanette. I'm conscious of time, so I'm going to pose two targeted questions to Diana and Ron, who ducked out of the last charter question appropriately. And then I'm going to close with a poll before we turn to audience questions. So the first question is for Diana. In a minute or less, impossible to do, I know. What are some of the pitfalls of other approaches that have been adopted, particularly in the UK, in this kind of regulatory space?
Thank you very much. Yes, well, very difficult to do in 1 minute, but basically in the UK, the draft online safety bill has been presented as the approach that would make the UK the safest place in the world to be online. And there are a number of reasons why the approach is very problematic. So just very briefly to highlight three of them. The breadth of the approach, very broad in scope, covers both user-to-user and search services, covers content that is illegal, content that is legal but harmful. to adults, content that is legal but harmful to children. Second, very complex, incredibly complex proposal. Services are divided into categories, each with their own duties. Duties differ on the type of content that they cover, and there are also duties regarding fundamental rights such as freedom of expression and privacy, and protecting content of democratic importance and journalistic content. There is doubt that these duties are workable. And third, discretion of the government. Under the bill, the Secretary of State has very broad powers to define the scope of the regulated services and the type of content that services need to deal with. And it has a lot of power over the communications industry regulator, Ofcom, that would be the body tasked to oversee the implementation and enforcement. So two main ideas to take away. Complexity makes it very hard to predict what the impact of this bill would be. It's not a quick fix. Secondly, important aspects are unknown. They remain to be set out in secondary legislation and codes of practice, and that poses big risks in terms of fundamental rights and the democratic scrutiny of the approach.
Oh, David, you're muted.
Once per call, every day. I mute myself. Thanks a lot, Diana. Ron, the question for you. It's about encryption. There's been some suggestion that this bill could potentially lead to a weakening of the power of encryption to safeguard rights in Canada, with the suggestion that there's a potential for police backdoors into services and those kinds of things. Your thoughts on those kinds of critiques?
Well, I think the use of encryption is certainly an important tool to allow for protection of privacy and to allow for consumers to have choice. So I think there's a lot of benefit to it. I think trying to mandate backdoors into encryption is quite problematic because, as we know, encryption backdoors, when they're made available, are used by all sorts of actors, including many malicious state actors for undesirable purposes. So there's meaningful consequences to mandating backdoors. I may have missed it in the law that there would be an obligation to build backdoors in, but I think there are ways to there are approaches that have been floated, different approaches to address some of the harmful content while still allowing for encryption. Of course, they're all balancing and trade-offs in some sense, but I do think it's requiring backdoors would be a very significant harm, so certainly hope that is not a feature of the final bill.
Thanks, Ron. Our final poll question for the audience. Some of the civil society critique of that emerged during the consultation period was that we needed to reopen this consultation from scratch, that we were starting it basically from the wrong perspective right from the get-go, and that we need to have a fundamental rethink on this. Do you agree or do you disagree? Alyssa, she'll post a poll on that. With that poll question out, we now turn it over to audience questions. We're going to open up the floor. Please use the raise hand function if you'd like to ask your question live. I see we already have some questions in the Q&A feature of Zoom. So I'll turn it over to Alyssa. Can you start us off by reading out one of the questions?
Yes. Okay, hold on. I'm just going to end this poll and share the results with you. And there is overwhelming support to reopen the consultation. Surprise, surprise. I'll stop sharing that. All right. So just a reminder to folks that you can raise your hand and ask a question live. I'm not seeing any hands yet, but I do have some written questions, and I will start with the one from Georgia Evans. And that is, should the government separate the 5 types of illegal and harmful content into different pieces of legislation, i.e. one bill for terrorist content, another for child sexual abuse material, etc.?
Why don't I field that question. I'm going to send, we asked a variation of that question. I'm going to put it over to Ron and see what his thoughts are on that. We've got a one size fits all piece of legislation. Is that the wrong way to start this?
Yeah, so I would say, I think that you should have in the legislation different metrics, different impact, different consequences. That shouldn't be one size fits all in how different types of content are treated. But I don't think that requires breaking it into 5 and then growing numbers of legislation. I think it can be addressed in one bill that properly deals with the nuances of different types of content.
Any of our other panelists want to weigh in on that? No, we canvassed that somewhat during our discussion. Back to Alyssa, our second question.
Yeah, I think I'm gonna, oh, I did see a hand, but I don't see it anymore. Oh, there it is, Josh Tabish. I'm going to give you the floor and allow you to talk. You're gonna get a push notification.
All right, can folks hear me?
Yes, we can.
All right, I have a kind of like thorny definitional question. When you look at the definition of online communication service provider, do you think it's too broad, or do you think that it kind of gets at what it needs to get at? I recall some folks saying that potentially this could be overbroad and include websites that have, say, comment sections in them. So I'm just curious to get your thoughts.
That's a good question. Anybody want to? All right, Kara, I'm going to charge in. Go ahead, Kara.
Oh, it's okay. Jeanette, if you want to go ahead, I'm sure. I think this is something you addressed in the submissions.
Sure. So I'll speak briefly and then I'll turn it back to you. I think there's a question both in terms of the scope as written and then the potential expansion of that scope. So as written, we've asked for clarification that they do of their intent, because there is some fuzziness. And so, yes, we currently believe that the intent is to target platforms that are engaging in the exchange of communication in a social setting. But there is a question mark, I would say, around its application to other types of online comments. I think the other point to be made, though, is that what the government did in the proposal is really open the door to further expansion, not just in terms of the types of services that are included in the regime, but also how it applies to individual services. So I think that's an area of uncertainty and raises a lot of questions about where this goes.
Kara?
Yeah, no, I would say I think it would be helpful ultimately in a bill to say, both what's clearly in and what's clearly outside the scope of the definition. And I can't recall exactly in the technical paper if this is one of the areas, but there are a number of things in the consultation paper where there's sort of a suggestion that a bunch of things might be addressed later by regulation. And I would say that, the scope of sort of the services to whom this would apply should not be one of those things that can be addressed later on by a regulation. It should be clear in the legislation, and attempts to broaden it should be the subject of legislative debate, not regulation by the executive.
I might add one thing to it, which is I don't believe the consultation had any notion of different scale of organization, right? Whereas I've seen other jurisdictions have, I think rightly, had different thresholds and burdens for very large platforms versus very small platforms. So, for example, if you put up a website to allow communication among a handful of parents, are you now suddenly caught as an online communication service? Since your primary purpose is communicating with other users of the service, right? I mean, there's cases where there'll be, I would guess, lots of effort to avoid dragging all kinds of small organizations into this definition, because there's no proportion or scale contemplated in the bill as I understand it.
Alyssa?
Great. Yeah, I will move on to the next question. This one is a write-in from Hossein Badran. And he asks, how does the panel view the structure and mandate of the proposed new regulatory body? For example, would the appeal tribunal be able to scale to the expected volume of concerned users?
So an administrative law question here. Anybody want to weigh in on the regulatory body? Kara?
Sure. My guess is no. My guess is no. They couldn't scale to the that, you know, if this was a system that was used, you know, robustly, that it would be very difficult for a body like this, which I think it is envisioned as maybe being comprised of 5 members, you know, along with presumably staff behind it, but. I think it would need to be a very heavily resourced body if it was going to deal with the scale of content that might be subject to this kind of, you know, flagging and takedown requests.
Yeah. Any other comments from anybody else on the panel? Ron?
Yeah, I would say I agree. I don't think given the scale of the complaints about violations that are currently happen, it's hard for me to imagine trying to put even a small fraction of those through a quasi-judicial process, right? And so I think you have to have other tools like metrics and audits and sort of manage it at larger scale while still having perhaps ways that exceptional cases or high stakes cases can go to a real tribunal, but there's got to be some high selectivity or representation of which cases need to reach that level of involvement.
Any other thoughts from the panelists? I'll just quickly comment. Sorry, go ahead, Jeanette.
Well, I just wanted to say, I think that it speaks to kind of part of the challenge here of building a regime and a regulatory structure around individual pieces of content. And when you're dealing at a volume, I mean, we have YouTube 500 hours of content uploaded every minute. We're not obviously the only platform implicated here. And so the scale that that this would need to operate at is really you know, kind of almost unfathomable. So I feel like, you know, if we shifting to a more of a systemic approach that looks at systemic non-compliance, for example, which could be an issue for some areas, and I think that that's a problem that, you know, you might want to have a regulator address and have tools to address, as opposed to trying to build something to tackle the individual pieces of content and individual decisions.
Thanks. I was just going to comment about the experience of the Office of the Privacy Commissioner. You know, that office is now you know, over 20 years old. In the early days, the complaints before the commissioner involved things like, you know, misuse of email on marketing lists and things like that. But very quickly, the technological well, just the knowledge, right? The technological savvy that was required of the regulator became incredibly a real challenge for that office. I mean, within a decade, we had a complaint before them about Facebook, and that poor office went from dealing with email to trying to understand what a social media giant like Facebook was doing. I can just imagine that right from the get-go, this regulatory authority is going to face very similar and challenging technological obstacles, barriers that will need to overcome to function. And it's going to have to be working hand in glove with many different social media and online communication services to be able to, you know, I guess, just perform its obligations under the legislation. This is going to be a very interesting regulatory body with some very interesting challenges. All right, with that out of the way, let's go back to Alyssa. Next question.
Yes, it seems we have a shy bunch. I don't see any more hands raised for live questions, but I do have a few more written in. The next one's from Marita Mole. With respect to child sexual exploitation, how much does the new proposal differ from what is already in place?
Anybody on the panel want to jump at that? Silence from the panel. Jeanette, I was about to pick on you because I know YouTube has to deal with this on the daily. So.
Well, I'm just trying to look for the actual language because what was proposed is, I think, as Diana mentioned, this concept of material that may relate to child sexual exploitation activities that does not constitute a criminal offense, but may still be harmful. And then the example that was given in the technical proposal, so you can find it there, is screenshots of videos that do not include criminal activity, but refer to it obliquely, sorry, there was, apologies, up-to-date photos of adults who were exploited or abused as children being posted in the context of their exploitation and abuse as children. So, you know, take that latter example, right? Up-to-date photos of examples who are exploited or abused as children being posted in the context of their exploitation and abuse as children. And absolutely, I think the intent there is to capture malicious activities. But as written, it opens up the door to kind of a broader application of that rule. And our concern was, you know, how would this play out for survivors, for example, who want to share their experiences, who want to share their stories. And, you know, as it's currently proposed, in our view, that could silence those voices, and that's an impact that we're trying to avoid.
Any other thoughts on this question? Right, back to Alyssa.
Yeah, I'll move on to the next one. So this one is the challenge is, oh, this is more of a comment than a question, but I'll read it into the record here. The challenge is how to legally characterize a content as terrorist, violent, hate speech, etc. Child abuse is probably the most viable, but there must be clear conditions to ensure that a supposed violation is an actual violation deserving of the label harmful. Would anyone like to comment on that?
Yeah, it's a challenge to the definitional work that we identified right at the outset of this presentation. Does anybody want to further comment on it?
Maybe I'll just say that I think it also, you know, it's also very relevant to the mandatory reporting piece that, you know, we're talking about areas that are difficult to define. And so if we're going to, you know, put people on the radar of our national security agencies or our law enforcement agencies, there should be a high threshold there. And I think that what's in the proposal right now is not a particularly high threshold.
Yeah, I mean, I'll just jump in and say that, you know, the consultation documents are actually vague, right? They say that they're starting with their criminal law definitions, but they may be tweaked for the regulatory environment. Well, the tweaking, that's everything, right? Like what does that mean? So we'll just have to wait and see what the definitions look like when the legislation finally is tabled. Any other final thoughts on that question?
I just want to very briefly to draw a comparison with the case of the UK and the Secretary of State, because what we see in the UK, for example, is we have illegal content and then we have legal but harmful content for adults or children, and the Secretary of State can actually, through regulation, choose what is the priority illegal content, and also they can make regulations about the legal but harmful content. So from a comparative perspective, my worry would be around this idea of regulation by the governor and council, and how much executive power there is to define the edges of these problematic categories of content.
Thank you, Diana. Elisa, back over to you.
Great, yes, and that comment was from Carlos Alberto Afonso. I'm going to flip over to a raised hand. Anthony Breton, I am going to prompt you to share your audio.
Okay, can you hear me?
Yes, we can.
Perfect. Good afternoon. Thank you so much for this panel. My question relates to, actually would probably be of interest to Mrs. Zeibel as well as Mrs. Patel. I understand there are two fundamental problems to regulating harmful online content. First one of them being its elusiveness. It's hard to suppress any content definitively from the internet. The other one being its intractable nature. It's hard to define what exactly is incitation to violence. Then my question is, why not addressing the causes of its spread instead of directly focusing on the content? I think Mrs. Zeibel has touched upon that a bit by discussing alternative ways, such as competition, regulation, or monetization advertising. So I'm curious to get a bit more, perhaps, of your thoughts on this.
Sure, I can start. I mean, I think this is sort of the whack-a-mole problem, right? That you can get something taken down from one place and it pops up somewhere else, and then you get it taken down from there, and it just keeps. It's hard to keep this stuff, offline. And I think, that does suggest that we might want to focus on different things. Some of it I think would be greater transparency around why you see what you see on a particular platform, and as I think Ron mentioned, potentially more choice for you in terms of what you see and what you don't want to see. Certainly, I think interventions in the area of competition law, which is not my area of expertise at all. So I won't, I don't know exactly what that looks like, but greater consumer choice is probably something that would be helpful for some of these issues. I think also, and maybe this is going to sound a bit defeatist, but I was reading a piece by a US academic who does a lot of work on content moderation issues, and she was talking about different options around not necessarily taking down content, but making it less visible, less viral. But ultimately, one of the things that she says, which I think is very true, is that it doesn't get you away from the fact that people on the internet are terrible. Sometimes people on the internet are just terrible, and that's not a problem that the law is going to solve. It's not a problem we can expect the law to solve, and it's probably, unfortunately, it's not a problem that technology is going to solve either. So I think that I don't. It's not that I think that this is an area where there should be no regulation, or that I don't recognize the harms that come from some of these platforms. I just think we need to be realistic about what law and regulation can achieve, and recognize that it's not the solution to everything.
Jeanette?
Thank you. I think, I will throw out there that this is actually an area where our machine learning systems and the automated systems play an important role, because while they might not be the best at making decisions that depend on context or nuance, they are really good at detecting patterns. And so that's why, that's how we address these issues at scale in being able to identify content, for example, so problematic content that is being re-uploaded. the machines can have an imprint of it and detect it to prevent that. We also, for example, when it comes to child sexual abuse material, have a system where we share the hashes across platforms, so that so it's not just limited to our ability to enforce on our own platform. Other platforms then can ensure that it is not being re-uploaded for their services. So there is a real role for machines to play here. They do well when we're dealing with volume and scale of the same material.
Thanks, Jeanette. And Lisa, I think Ron, you had something that you wanted to add?
Yeah, I just wanted to build a little on Kara's comments, because I think it's absolutely true that like there's no simple fix, right? There's not like a silver bullet to come out and just fix all the problems, right? But instead, I think what we really are seeing is the importance of regulatory approaches that keep up with the technology, right? Like we're big believers at the Schwartz-Reisman Institute in this idea that we need to unleash market power to create entrepreneurial incentive to do better, right? So that means things like, can you create private sector innovation to better audit and certify the outcomes of AI algorithms, right? Can you create market structures that allows for competition among different providers to improve user experience on top of these platforms, right? Because I think the best we can do is give incentive to make things better and to have a thoughtful regulatory structure where there's minimum rules of the road the government sets, but the government isn't trying to weigh in and do things like dictate, even for legal content, which one should be suppressed, right? I don't want to see that precedent. There was a good question in the chat that pointed out that precedents like that can be very harmful when they get used as justification for less free countries to say, look, free democracy like Canada is doing it. This is okay. And we don't want those precedents, right? So I think the answer has to be about empowering choice for the public and about creating market incentives to improve things.
Thanks. And back to Elisa, I think we have time for one final lightning fast question.
Yeah, okay. So the next one I have chronologically, I think that we've kind of talked around this, but on non-consensual image sharing, many years ago, a baby was pictured and featured on a Nirvana album. Grown up, he's now unhappy with that. How does one differentiate between such and more obvious revenge porn or other absolute non-consensual sharing of body images?
Does anybody want to tackle that complicated question? It's a difficult one because consent is messy in that particular case because the legally authorized entity who was able to exercise consent on behalf of the child in the image had consented, and it's an after the fact complaint, and I think it's also we do get into definitional challenges here. Anybody have any thoughts?
I don't have an answer, I guess, per se, but I think, it does point to how different that category of content is from some of the other categories that are in this proposal. That category of content really does require some dialogue with the subject of the image to know the background behind it and how it ended up where it did. I think the Nirvana baby is sort of a different example, because as you say, first of all, there was consent by the people sort of legally empowered to give it, whether we agree with that or not. And it was also I think also that there's probably different treatment for images that are used for commercial purposes versus images that are just out there. But I think, yeah, it gets to some of the complexities with some of these different categories of content.
Thank you, Kara. Well, I see that we're coming up to the end of our time together. So I want to take this opportunity to thank each of our speakers. Thank you, Ron, Kara, Diana, and Jeanette for spirited discussion, and to my colleagues on the planning committee. And most of all, I want to thank you, the audience, the participants, for joining us here today. Please stay tuned for more from the Canadian Internet Governance Forum. We aim to bring another session in the speaker series in February, and we look forward to seeing you at an in-person event as soon as it is practical to do so. Thanks, everybody.